question I am commonly asked by my clients is, when can a child decide where they live? There is no right answer to this question. When there is a family dispute in relation to a child's living arrangements, a child's views is but one of 16 factors that a court takes into account in determining what orders are in the child's best interests. Importantly, a child's views are not one of the primary considerations taken into account by a court. The primary considerations that a court looks at in determining what is in the best interest of the child are: number one, a child's right to have a meaningful relationship with both parents, balanced against number two, the child's right to be protected from harm. Now, the weight that a court gives to a child's views will depend on a number of circumstances, including the age and maturity of the child, the level of understanding of the child, and whether their wish is well informed or whether their wish has been influenced improperly by another person. A court finds out what a child's views are through the process called a family report. A family report is done by an experienced social worker or psychologist who interviews the parties, the children and significant others, and observes the children's relationship with those persons. The family report writer will ask questions of the child about their views and other significant matters to determine the child's level of understanding. The family report will then be produced, which includes, amongst other things, the child's views and recommendations as to what is in the child's best interests. Importantly, those recommendations will not always accord with what the child's views are. The family report will then, generally speaking, be given some weight by the court as to what orders it makes in the child's best interests. In summary, there is no set age when a child's views are accepted by a court. Rather, it is just one fact that the court takes into account in determining the child's best interests. However, the older the child and the greater their level of maturity, the less likely a court is to make orders which are contrary to that child's expressed wishes, particularly once they reach their mid-teens, when that child can vote with their feet and place themselves physically where they want to be. It is at that point that a court is reticent to make orders which are contrary to the child's expressed wishes. If you are unable to reach an agreement with the other party in relation to the living arrangements of your children, court should always be a last resort. Child-inclusive mediation is a fantastic way of having the child's views heard and considered as part of the process.